Okay, so typically after discovery is done, after we get all this information, we sit down and we have a mediation. This is not binding. This is not law. This is no judge. This is somebody that could be an attorney, could be a judge, just going back and forth between the parties, yourself as the plaintiff and the defendant's insurance company and their attorneys, to see if we can come to some sort of agreement that you walk away with for payment for your injuries. Mediations, depending on how complex your case is, it's like a mini trial, but it's not binding. You're selling your story to the defense and they're selling their story to you. A lot of times, even though it's confidential, you show your playbook or they show their playbook. So mediation is a chess game, but you want to present a case strong enough that way the defense attorney can say, we're going to have trouble at trial if this happens. Mediation is like a mini trial in a sense, because that's when you start talking numbers. In mediation, that's where many times cases settle. Not always, but many times. Whenever both sides come together, you go back and forth and hopefully come to an agreement that you can be happy with and walk away with money for your injuries. This process is not a very fast process. It's a one-day process, but it takes hours many times depending on how complex the case is. But for the most part, a minimum of 3 hours or 4 hours, and you just go back and forth. It's like you're bargaining the whole time. But mediation is important because the courts require you to have mediation, because they're trying to avoid trial and tying up the court's time. If you don't come to an agreement in mediation, and then the next step is going to trial. If you have any questions on this, give us a call, 833-4-BAD-DAY. Thanks.